believe, according to my list, Mr. Murray is next. Go ahead.
Thank you, Mr. Chair. Mr. Rorie, I'm over here, over your right shoulder. So let's logistically make sure we have something that works here. Sometimes what we found is when I'm asking questions, the tendency of the witness perhaps is to miss that microphone. So just wanted to kindly inform you that this has been a problem, okay?
Okay.
And if we run into that problem, we'll just stop and reposition, okay?
Okay.
All right. I represent a couple of landowners in this case, and I've got quite a few questions for you. I'm going to start with where the Iowa Farm Bureau had asked you about the temporary construction easement, okay?
Okay.
As I understand it, Summit wants a non-exclusive temporary construction easement, is that correct?
Yes.
And by non-exclusive, would it be correct to say that Summit cannot prevent a landowner from coming upon their property while during a temporary construction easement period by virtue of claiming that the landowner is committing a trespass? Would you agree that Summit cannot claim the landowner is committing a trespass in that situation?
Objection. Calls for a legal conclusion. Mr. Rorie, you may answer if you know the answer. Otherwise, Mr. Murray, you can restate.
Trespass is a strong word there. The rights that we're seeking involve non-obstruction during construction. So I believe if the landowner was getting in the way during construction, then that would be violating the rights granted or the agreement that we reached. But in terms of accessing that easement, temporary construction easement, outside of construction, to the extent that it didn't affect anything, I don't think we would have a huge problem with that.
And I do appreciate how Summit is approaching this issue in contrast to Dakota Access. For purposes of this question, I'm not talking about landowners who attempt to block work or to create a safety hazard or to disrupt work in any way. I'm more interested in landowners being freely able to inspect the work while not getting in the way. So in that context, would you agree that by including the word non-exclusive, a landowner has the right to go on and inspect construction firsthand?
I would agree with some of the rules that are in place about tile repair inspections, things of that nature. It is complicated on a mass scale to escort landowners into the construction footprint for safety reasons. It puts us on everyone's property longer. So I wouldn't agree that landowners hanging out in the right-of-way during construction is a good idea. But I would commit that we would comply with the rules about certain types of inspection.
So in this example I'm going to provide you, crews do work on the property, and those construction crews have got to go home and get some sleep, okay? And so they go. They're done for the day. They'll come back tomorrow. In that situation, would it be Summit's position that a landowner can go out on their property and take a look?
That happens often. I don't think we would have a problem with that. The caveat there is that as long as they don't do anything that causes us to be delayed as a result of their actions, and you mentioned the word attempt, they don't necessarily have to attempt to do that. That can just happen by disrupting things. So as long as they didn't do anything of that nature, I don't see us having a problem with it.
And there are personnel that address safety issues with Summit and also, of course, with law enforcement, right?
Yes.
And so a landowner that might say to that contact person, be it through Summit or law enforcement, that says, hey, I just want to make sure everybody knows I'm going to go out there and I'm going to check this out. That would be a pretty good measure of how to do this sort of thing, isn't it?
That would be one of them.
Yeah. Okay. Mr. Rorie, I recall some of your testimony last week, but you're going to have to help me out in characterizing your testimony correctly in this regard. I believe you were asked about whether Summit would agree to, I'm going to characterize it as preconditions upon the requested permit approval from this board. Do you recall giving testimony in this regard?
I'm not sure I understand the question. Can you help me there? Preconditions.
Yeah. Well, stated specifically, the state of North Dakota has not granted a permit. So, would an example of a precondition on this board granting a permit might be to say, this board's not going to grant a permit until North Dakota grants a permit. Would Summit, did you provide some testimony in this regard last week?
I was asked the question last week about whether I thought we ought to get a permit without other state permits in play, in which I responded, yes, I think we ought to. We ought to seek a permit in Iowa regardless of how things are going in other states. I think some other witnesses talked about whether or not there would be preconditions or what someone would agree to.
Now we're talking the same language about what your testimony was last week. So, as I understand it, just very straightforwardly, Summit wants to take the CO2 to North Dakota to store it within underground caverns, correct?
Yes.
And to get to North Dakota, we have to go through South Dakota, correct?
Yes.
Now, we know that not only has North Dakota denied this permit, but now we learned over the weekend, or at least yesterday, that South Dakota has not granted its permit to Summit, correct?
Not yet. Yes.
And you can affirm that that denial occurred yesterday, correct?
It's my understanding.
Is there anywhere else that Summit intends to take this CO2 besides North Dakota?
Not to my knowledge. Don't really make those decisions, but not to my knowledge.
What does Summit know that would guarantee that South Dakota will eventually change its position and approve this pipeline in that state?
What does Summit know that would guarantee we would get a permit in South Dakota?
I think that's a good characterization, my question.
Well, we know what type of traction we've made in South Dakota. We understand the rules tied to that, and we're confident in our ability to obtain a permit in South Dakota. As far as what we know, I don't know that there's any guarantee.
So isn't it possible South Dakota will not grant Summit a permit? Isn't that a possibility?
I don't like to think that way, but I guess it's a possibility.
Lawyers have to think that way, and I would suggest perhaps maybe Summit might need to consider these possibilities that you may not get that permit in South Dakota. I think you just affirmed that, right?
I think any pipeline project that needs a permit considers the possibility of not receiving one.
So, obviously, if I asked the same question about North Dakota, you would similarly answer, correct? There's no guarantee in North Dakota either, correct?
I don't think there's any guarantee in anything.
So, since there's no guarantee and since it's possible that these permits may not be granted in these other states, and since the only place to go with the CO2 is North Dakota, isn't it a possibility you're installing a pipeline to nowhere?
I don't see it that way. I don't think about how things are going in other states as it relates to what we're needing to get done in Iowa. Yes, if we built a pipeline that didn't have a terminus, then I guess that would be a pipeline to nowhere, but that's not the way I see it. The way I see it is certainly the time we're spending this morning is to seek a permit in Iowa and make sure that we accomplish all of the criteria necessary to do so.
it's always important to wear someone else's shoes when negotiating with them. Mr. Rorie, would you agree?
You have to elaborate for me on wearing other people's shoes.
Well, the golden rule, let's just say. You're trying to build relationships as you stated in your testimony, right?
Yes.
And you just said the way I see it. Well, if a landowner sees it that a pipeline is going to be installed after adverse condemnation on their property, they would see it a little differently than you, wouldn't they?
They could. Landowners see things in many ways. So do we.
But it would be fair for them to say that a pipeline to nowhere after having eminent domain taken, that perspective, if you were to put yourself in the landowner's shoes, is kind of an objectionable thing, correct?
I don't agree with that.
If the tech expert or party can publish Murray Hearing Exhibit 1, I would appreciate that. Okay, so on the screen there is Murray Landowners Hearing Exhibit 1. You see that there?
I do.
And I'm going to represent to you that this is a final decision in order of the Iowa Utilities Board, March 10, 2016, concerning Dakota access. Would you agree this appears to be the caption, at least on the screen, right?
Appears to be the caption, yes.
The Dakota Access Pipeline was an oil pipeline from the northwest corner of the state down to the southeast corner of this state, correct?
Yes, that's right.
Coincidentally, it also involved a terminus in North Dakota, correct?
It involved a terminus in Illinois.
That's a terrible question, isn't it? You're right. The terminus, the oil went to Illinois. It came from where?
From North Dakota.
I see. So I'm going to go to page 4 on this exhibit, if I could. And down below the introduction, I'm going to see that number there that's about 6 or 7 lines down. And it appears to show that we have an oil pipeline through Iowa as a part of a 1,168-mile project to carry oil from the Bakken area. That would be the number of miles in Iowa that were affected by the Dakota Access Pipeline, correct?
346, I believe, if I'm reading that right. 346 are the miles that related to Iowa. The entire project from North Dakota to Illinois was 1,168 miles.
Thank you for that clarification. Your COO correctly chastised me for my math, so I better write it down.
That's okay.
Okay, so let's compare. Your pipeline in Iowa is how many miles?
686 miles.
And total miles for the entire project?
Just over 2,000.
Do you have a specific number?
2,060 miles.
All right. Last week, you had clarified as a part of your direct testimony that there were a certain number of holdout parcels at that time concerning Summit. Do you remember that testimony?
I don't. recall calling them holdout parcels. Are you talking about remaining parcels?
I suppose, yeah. Remaining parcels to be signed. Is that?
That's right.
Okay. So, with respect to the remaining parcels, how many were there last Tuesday?
Last Tuesday?
I think you testified 892.
I want to be perfect here. I don't recall exactly on Tuesday. I testified on Friday. Oh, or Thursday, I'm sorry.
Yeah. No, I think it was Friday. I'm going to help you. It was Friday. So on Friday, let's correct my question. On Friday, didn't you say it was 892 remaining parcels?
Remaining parcels, that's right.
How many is it today?
It's going to be right around there. There's a cancellation period in Iowa, so I would still say 892, even though we reached agreements this weekend.
Okay. Now, if we go to Exhibit 1, which just came down, we're going to go back there. If we go up to page 2, and we just scroll down a little bit there to the bottom of that page. Okay, right there, it says individual eminent domain parcels. And in the ruling, it shows page 122 of that IUB ruling where it addresses those eminent domain parcels, okay?
Okay.
And so below there, we've got Mr. Burkett, and he's got a parcel number there, H-BO-001. That looks kind of like the way you guys in Summit identify parcels, correct?
Looks similar.
Okay. Now, if we scroll down in this to page 4, you can just, I'm not going to ask you to count these, but I'm just going to, if we can slowly go through that. Let's go up to page 3. We went through quite a few there. We're on page 3 now. Let's go scroll down page 3. And then we go on to page 4. And this listing of eminent domain parcels appears to end around page 151 or 152. At least that's what the table of contents shows, correct?
That's what the table of contents shows, yes.
I'm going to hesitate to say that I counted this up over the weekend, and I'm going to say that the number of eminent domain parcels was a little bit below 50 parcels for Dakota Access, okay?
I don't know if that was a question, but I know your math is wrong there.
What was it?
Well, there's certainly more than 50 parcels that were being discussed. This Dakota Access was heading, well, I guess by the time they got their permit, maybe it was 50 parcels. Maybe you're right there.
Well, I'm just saying that ruling concerns less than 50 parcels in Dakota Access. We can count that if you like, but that's what it says.
I think you may be right that I'd have to, I'll take your word for it, but I think you may be right that by the time they received an order and headed into construction with final conditions, perhaps it was that low, but I think there were hundreds of tracks.
Your Honor, if I may.
Go ahead.
We'll stipulate that this is the board's final decision in order in the Dakota Access case dated March 10th, 2016. I think the board's aware of its precedent. If we could ask the witness questions that aren't already encapsulated in this document, I think that might speed things up a bit.
Okay, thank you. Go ahead, Mr. Murray.
We'll offer Murray Landowners Exhibit 1.
Is there objection? Seeing none, the board will admit Murray hearing Exhibit 1.
How many total parcels in Iowa are affected by the Summit pipeline?
3,305.
And I imagine you're not aware of the total number of parcels that were affected by the Dakota Access Pipeline, are you?
It's in the 1,200 range, 1,275, something like that.
Okay. I think, did you testify during somebody's questions? You threw out a number of 1,200 landowners who have signed. Can you give some context to that again? What were you talking about there? Did you say that?
I said 1,210 landowners have reached an agreement with us voluntarily in Iowa.
Okay, so that I understand this, there are 3,305 parcels in Iowa and 892 parcels yet to be signed, correct?
There are 892 parcels yet to be signed. Roughly, I believe we got a couple this weekend, but can't count them yet.
Yeah, right, roughly. Okay, so the differential there is, again, challenging to me. 2,400 or so parcels have been signed.
2,413.
You would be a guy that would know that number, right? So of those 2,413 parcels who have signed, it only took 1,210 landowners to commit those parcels.
That's right.
How many landowners do you need signatures from concerning the 892 or so remaining parcels?
469.
Thank you. Wanted to explore a topic about major versus minor route changes, okay?
Okay.
Can you define the factors which would characterize a major route change?
I'm not sure I understand that. The factors that would. Could you help me there?
Well, Summit has used the term major route change versus minor or macro route change. I'm trying to understand it, and I'm wondering how Summit distinguishes between the two. So in that sense, I'm looking for factors that Summit utilizes to make a distinguishment between these two.
Well, a major route change would be a variety of things that would cause us to encumber a significant amount of additional landowners, maybe a lot of additional pipe, or just maybe a totally different direction. So what we cited were micro changes, which would be the opposite of that.
Yeah.
But there are plenty of examples of all types of major route changes. We typically don't do those.
I would imagine that if there were a route change which affected, for example, a previously planned valve that caused a change of the valve, that would be a major route change, correct?
It's a factor.
You would say a strong factor, wouldn't you?
Could be, depending on where we need to put the new valve as a result of that route adjustment, whether or not that fit all the criteria for our valve spacing and other issues there, but it could be a part of a major route change.
Other pipeline infrastructure might factor into the distinction between these two characterizations of major versus minor, correct?
Other pipeline infrastructure could factor into either.
Physical characteristics of the land?
Yes.
Your COO, Mr. Powell, had testified, and I want to make sure that I only say I'm paraphrasing his testimony here, but I think he testified that I don't intend on amending the application. I think this had to do with route. Today, would you affirm Mr. Powell's testimony?
I'd have to listen to all of his testimony to see how he elaborated on that, or if he did. So it's hard for me to affirm his testimony, but I can tell you that I report to Mr. Powell, so I'm going to do what he directs me to do. I think his testimony would stand on itself.
Very true. I had a 5-minute cross-examination to the T of Mr. I think it's Skubanek. Is that pronounced correctly?
Yes.
Amazing. I think I established with him that Summit is not proposing any possible alternate routes to the Iowa Utilities Board. Would you affirm that testimony today?
Objection, Your Honor.
State your objection.
Calls for a legal conclusion, misstates the petition in this matter, which includes an Exhibit F describing alternative routes.
Thank you. Mr. Murray, do you want to reword that? Mr. Rorie, you can answer the legal conclusion component of it if you know.
I really don't.
Are there any possible alternate routes that you can identify to the Iowa Utilities Board today?
Possible alternate routes? I don't know that I can identify any of those today. I think part of that is that I don't route the pipeline.
Have you seen Navigator's easement documents that it negotiates with landowners?
I have.
And you're aware that Navigator's easement has an option that envelops their easement, correct?
Help me understand envelops.
Well, as I understand it, and correct me if I'm wrong, that there's a document entitled something to the nature of an easement, and then there's a separate document that is entitled option. But if could you affirm that there appears to be two different documents there?
I can't speak for Navigator and everything they're doing on their land acquisition side, so I'm hesitant to do that. I work for Summit, but the brief glance that I've had at documents tied to that project, I've seen some that are tied to options, if that's what you're describing, but it's going to be hard for me to go into details of a pipeline project I don't work for.
So you've looked at the Navigator documents and you have knowledge that there is option language in those documents.
I've seen some. The entirety of their documents, I don't have a clue.
So would you agree with me, or at least you have knowledge as to the general nature of the amount of the option payment?
Objection, Your Honor.
State your objection.
I'm going to object to relevance as to the content of another pipeline company's voluntary easement agreements not involved in this docket.
Okay, Mr. Murray.
Well, it is background information as to the question of Summit's easement and how Summit's easement appears to be locked in rather than including option language.
Okay, we'll appreciate the background. If we can get to the question, please.
You are aware that there is option language in those Navigator easements, correct?
The few that I took a look at, yes.
By contrast, Summit does not employ or use options, correct?
We employ options, we use options sometimes when it comes to fee purchases.
But not with respect to easement purchases from landowners such as the ones I represent.
We haven't to date, no.
So rather than adopting this absolute stance, wouldn't Summit have made it easier on itself with routing by adopting Navigator's practice of utilizing option language?
No. Not in the least.
I'd like to get into factors that go into Summit's determination of whether an alternate route is possible. Do cultural factors factor into that? Indian bones are out there. Is that something that affects alternate route issues?
I don't use the term Indian, but there are a number of factors that play into altering the route of a pipeline. Cultural resources could come into play there if they were a factor, but there are a number of parameters and criteria you have to look at when you're changing the route.
There's other environmental factors that go into play there too, aren't there?
Could be.
Would the willingness of a landowner to give an easement be a factor as to whether an alternate route is possible?
Could be.
And on the flip side of that, conversely, the unwillingness of a landowner is also a factor that affects the possibility or impossibility of an alternate route, correct?
Could you frame that differently? I'm not sure I understand.
Yeah, I'm just going to withdraw the question.
Okay.
Summit has the authority under Iowa law, as I understand it, to perform surveys by giving a notice, and then they're out there taking a look at the ground. So that's not a question. I'm just going to frame it in a question to you. Are you involved in decisions at Summit to go ahead and perform those surveys?
I don't direct the survey activity as far as the decision to perform them. I'm involved in procuring the permissions or the consent of the landowner to survey.
Even with an unwilling landowner, Summit has had the opportunity to go out and survey property, even though they're unwilling. Isn't that correct?
That's true.
So if you have the ability to survey property upon an unwilling landowner, the willingness or unwillingness of that landowner really is not an issue, is it?
Well, it's certainly an issue. I'm not sure I understand the definition of an issue.
I'm sorry, I cut you off.
I'm not sure I understand your definition of an issue, but...
Well, we're talking about the factors that Summit uses to determine whether an alternate route is possible. So in that context, I'm trying to figure out why the willingness or unwillingness of a landowner has anything to do with Summit's determination of a possible alternate route.
Well, it has a lot to do with altering the route, especially in the event that neighboring landowners may have been, as you're referring to, willing. So if we're being asked to consider altering a route on a parcel that would transfer impacts onto landowners that have already reached an agreement with us, then what we're being asked to consider is to change the commitments that we made with that particular parcel's neighbors in order to accommodate that parcel. So that is always a factor that we have to look at to decide whether or not that fits. Because what it does is it invites other people into the conversation and puts us in a position where we need to change our commitments and ask more of the neighbors in order to accommodate that particular parcel. So it's a factor.
I was going there next about adjacent landowners. It's amazing. Our minds think alike. But let's go back to my question, which had nothing to do with adjacent landowners. My question was within the context of that parcel, assuming there's no change in the entry or exit point upon that parcel, why would the willingness or unwillingness of a landowner affect the possible alternate route on that parcel?
There's just so many factors involved with this, Mr. Murray. I mean, willingness and unwillingness, it's a broad word.
Why?
So,
why is a broad word? You're right about that.
Well, willingness. I mean, there's a lot to consider when it comes to changing the route of a pipeline on a particular parcel. One of the things you talked about at the first part of your question was the entry and exit point. It is very rare to change a pipeline route and not alter the point of terminus and point of beginning. That's rare. So that's not the most common outcome. But unwillingness doesn't really create a big incentive for us to go through a number of exercises, to your point, cultural environmental review, constructability review, potential costs, potential additional impacts on that parcel alone, timing, waterway crossings, reclamation, etc. So all of that goes into play in our decision of whether or not it's feasible to change the route. But if a landowner is unwilling, period, to work with us, I don't know that it's reasonable to ask us to make a number of exceptions like those I just cited to end up at the same point. We're not going to be in agreement, which is driven by the landowner in the instance I think you're describing.
Let's go back to that last point you just mentioned in your answer. And here's my question, again, as it relates to just that landowner, not adjacent landowners, okay? What if a landowner who's not willing to sign an easement, but he tells Summit, don't put it there, put it somewhere else on my ground? Is that a factor that Summit considers?
It's a part of the overall review of the scenario, yes.
So even though the landowner may not sign an easement, says, I don't want any of your business, but if you're going to put it somewhere, Summit will have to consider that as a possibility, won't it?
I don't know have to, but we certainly would take a look at every request the landowner gives us.
Now, let's go to these adjacent landowners. I think you had brought that subject up earlier. What if a landowner is not willing to sign an easement, but there's an adjacent landowner right next to him who says, yeah, sure, I want the pipeline on my property? Is that a factor that Summit considers?
Doesn't come up often. I guess it would be part of the conversation.
And even extending this question a little further, what if we have a landowner not willing to sign an easement, but there's an adjacent landowner, hang with me here, who has on a different parcel somewhere else, he's actually signed an easement somewhere else in that county? That's a factor that also comes into play. You have a willing landowner who's already given you easement, and he's right next to this unwilling landowner with another parcel. But that's a big one too, isn't it?
I don't know what you mean by a big one. It's very rare, and we look at the particular parcel to be impacted, don't typically look at the idea that someone may have signed an easement elsewhere. We have landowners that own property in multiple states on this project. I wouldn't, if we were looking at a route change, we would look at where the pipeline is being proposed to go. I think also perhaps your definition of willing is much different than mine. There's a lot more that goes into it.
Thank you. Tech, can we publish CROT Direct Exhibit 1? Wait a minute, is it 1? Yeah, CROT Direct Exhibit 1. Okay. It appears that we have on the screen CROT Direct Exhibit 1. You have it there in front of you?
I do.
Okay. I'm going to represent to you that this is a map of a parcel owned by one of my clients, the CROT Trust. CROT is Kracht. Are you familiar today with this parcel?
I am.
So then, as you look at this parcel, and this, would you agree with me that this appears to be a map published by the county assessor in Lyon County?
It could be.
It certainly isn't a map that you publish, right?
I don't think so. I don't control all of our maps, but I don't think so.
Yeah. I publish is the wrong word, create.
I don't believe we did, but it's an engineer or somebody created that.
Now, there is a white area on that map from the south that comes from what appears to be a road, and it meanders from the central lower part and goes upward to the northeast and exits out the east side of this parcel. Would you agree with my depiction of that white area?
Yes.
That's a water area, isn't it?
It appears to hold water outside of the thaw, yes.
Are you familiar with the topographical features of this parcel as it relates to elevation?
I don't know the exact elevations. I can see that there's some elevation change, but I couldn't list the margins of topographical elevations there.
The Big Sioux River is our west boundary in Iowa, and as it relates to Lyon County, correct?
Yes.
And how far is the Big Sioux River from this parcel?
Couldn't tell you. It's not terribly far, depending on your definition of far, but I couldn't tell you the exact distance.
I'm going to ask the tech chair to publish an Exhibit H that was filed on September 12, 2022 concerning the CROT parcel. Oh, before I do that, I'd like to enter CROT Direct Exhibit 1.
Is there objection?
No objection.
All right. CROT hearing exhibit 1, is that?
Oh, actually, it's Direct Exhibit 1. It was attached to Mr. CROT's testimony. I'm fine with entering that as an exhibit when Mr. CROT testifies. Is that what the board's preference is?
Yes.
Sorry.
No worries. Thank you. Appreciate that. So, withdrawing that.
I'm withdrawing it. We'll get it on there with Mr. CROT.
Thank you.
Okay. What we have on the screen now appears to be a filing by Summit on September 12, 2022. And I'm going to suggest that the ownership information references my client, Mr. and Mrs. CROT, trustees of their trust, right?
Okay, sure.
Let's go down to some page that has a map. Tech. Okay, there we go. What page is that? I can't even see it. 5? Thank you. So on page 5 of this thing, okay? Let's get it on the screen. All right. So you see there, this is a map that was produced at the direction of Summit, correct?
Looks like that's the case, yes.
This is a map that was produced by Summit, presumably following a survey that Summit conducted on this parcel, correct?
Yes.
This was a map produced after a survey in which Mr. Crott asked Summit to consider pushing the pipeline to a boundary, correct?
That looks like that's the case, yes.
So that way, what we can do is we can say this is what we would call the boundary route. If I refer to the Crott boundary route, I'm referring to this route right here on the screen, okay?
Okay.
All right. Take a look at how this comes in on the south side, all right? On the south side, you see where it's located there?
Yes.
All right. Now, you testified earlier that it's extremely rare that we have a change that does not involve a change of an entry or exit point. Do you remember that testimony?
Looks like the exit point. I'm not sure I understand your question. You're talking about the entry point there?
Well, when we have route changes on a landowner's parcel, I think you testified that it's extremely rare when a landowner has a route change in their parcel where it doesn't also affect entry or an exit to that parcel, correct?
I did testify to that, yes.
All right, thank you. Let's now publish another Exhibit H for this individual on April 18, 2023. And go to page 5, I guess. Okay. All right. So this is another map dated April 18, 2023. At least it was filed on that date concerning this same landowner, correct?
I'd have to take your word for that. I don't have evidence of the filing dates. Looks like the same route to me.
That's what I see. I see that this is the same route on April 18 as it was on September 12 of 22. Looks like it, doesn't it?
Looks very similar.
If the tech person could scroll to the top of this page and look at the filing date, that would help the witness. So you see it says April 18, 2023 there, okay?
Okay.
All right. So Summit filed this on April 18, 2023, not changing the route, correct?
From what I can glance at, yes. I don't know if there's some technical differences in those two. I didn't draw it, but it looks very similar.
Look at that that feature there. It says pond right there on the right-hand side, correct?
Yes.
So there's that pond. Let's go to July 14, 2023, another Exhibit H. Now, on page, you see where it says July 14, 2023, Mr. Rorie?
Yes.
That's when Summit filed this document, correct?
Looks like that's the case.
Okay. So, is this also page 5? I think it is.
Are you asking me? Yes.
No, I'm not. I'm not. I'm going to suggest to you this is page 5 of this document, Exhibit H. Would you agree with me that this page depicts a much different route?
Certainly different, yes.
And would you agree with me that as it comes upon this property on the south side, it looks pretty much the same, doesn't it?
The south side looks like a similar point of beginning, yes.
Okay. You are aware that Mr. Crott has advised Summit that this pipeline route is objectionable, aren't you?
That's my understanding.
And you are
the other route.
I'm sorry, I cut you off. What was the
It's my understanding that he prefers the other route, or your client does.
Yeah. Mr. Crott has made it abundantly important to him that this route is on a ridge area. You would affirm that fact too.
I haven't stood out there to tell you whether that's on a ridge area. I can tell you that That route has a lot less trees in it and crosses a drain once and still stays out of that pond that you showed. So I'm not a construction expert, but I can speak to it in layman's terms, that that's a more practical route constructability wise, impact wise, etc. when it comes to the construction side of things. I'm not sure whether that's a ridge or not. It may be helpful also, and I don't know if I can request this, if we could pull up the KMZ to juxtapose what things look like on either side of that tract as it relates to this route. I think that would help with the picture for me, at least.
I'm going to rely on my client's testimony to confirm that's a ridge.
Okay.
I want to push forward in my questions.
Understand.
So
I may have a little difficulty answering them
I understand.
if I can't see what's happening on the other side of the property line. So I think a KMZ would be helpful. I don't know who I request that from.
I'm sure that you'll have an opportunity to do that
Okay.
on other questions.
Okay.
I think I can establish it through my witness. But moving away from the topographical issue here presented, as we go back to September 12, 2022, at that time, if you know, was Mr. Crott represented by counsel?
I don't know.
Would you agree that in late June or early July of this year, I communicated Mr. Crott's offer to Summit through its counsel? You can confirm that, right?
That sounds correct.
And prior to my involvement, communications were by and large between Mr. Crott and your right-of-way agents, correct?
It's my understanding, unless he had previous counsel, I'm not sure.
And since late June and early July, Summit provided a responsive counteroffer not until September 6th, correct?
I'm not sure the exact date.
But you can confirm that it was in early September, correct?
Again, not sure the date there. I'm not sure a counteroffer was presented.
I have a stipulation with counsel, and maybe Mr. Leonard can help and stipulate that the counteroffer responsively was given in early September.
So stipulated. Thank you.
So to sum this up, shortly after my involvement in late June and early July, when I communicated an offer to Summit, instead of countering at that time, changed the route from the boundary route to a route that he didn't want. Would that be a fair and accurate representation?
If you're representing that the route we changed it to was one that he didn't want, or the original proposed route on that property prior to the original Exhibit H being filed, I guess it would have been September of last year. I think that's right. Okay. We received a counteroffer from you.
Okay. All right.
We went back to the more practical route.
Okay. We're going to go to DePayma. Let's put up DePayma Hearing Exhibit 2. Okay. Can we go to the top of that thing or the bottom? Let's go to the bottom of that thing. Huh. Well, DePayma Hearing Exhibit 2, this is an overhead that I'm going to suggest to you is created by the county assessor of Kasuth County. Does it look like something that this could be?
It's possible.
Okay. And for demonstrative purposes, I'm going to suggest that DePayma's parcel is depicted on this exhibit. Okay?
Okay.
So, are you able to, with first-hand knowledge, confirm that this appears to be what it is?
I really can't confirm whether it appears to be what it is. I've not seen this rendering. It's your map. It's not ours. My understanding it is not.
Okay. Well, for demonstrative purposes, I'm going to suggest that it is.
Okay.
Now, do you see where the roads lie on this assessor parcel map?
On the parcel map, yes.
There is a road on the south which appears to be, I'm going to suggest, a quarter mile away from that 40, correct?
Could be.
And there's a road to the east that appears to also be a quarter mile away from this 40. Okay?
Okay.
Would you agree that that's what this map appears to show?
I'd have to measure it out. I can see the roads to answer your question.
Mm-hmm.
Hard to confirm measurements for you.
Well, you see, these assessor parcel maps have been a phenomenon in Iowa. People use them all the time. And you as a landman would know that how many acres are in a section of ground?
Yes. So the measurement you're talking about as far as the parcel itself sounds right. Where the pipeline is on the parcel, I can't tell you exactly the proximity to the roads. So perhaps I misunderstood your question. The parcel rendered being a quarter mile one way or the other, yes, that seems right to me.
Yeah, these county assessor parcel maps start with usually 40-acre parcels, right?
Correct.
We can agree to that.
Yes.
And we can agree that if you've got one of these sections in Iowa, you're going to see 16 of these blocks in a section, right?
Sounds right.
And each one of them has a width and a height of a quarter mile, correct?
Right.
And so where I was coming from was from that general background. I'm saying that this parcel is a quarter mile away from each road, whether it's south or east. Wouldn't you agree with that?
That looks right to me.
All right. Okay. Offer the payment hearing exhibit 2.
No objection.
Hearing no objection, the board will admit DePayma hearing exhibit 2.
Let's go to the payment hearing exhibit 3. Okay. Now, this appears to be a similar map. It's just another parcel located to the north of the one we previously looked at, correct?
Looks similar to me, yes.
Now, if the tech can put the little hand up in the upper left-hand corner, way up there in the upper left, there it is. Read where it says owner. Who's the owner here? Go ahead and read it out loud.
You're asking me to read that out loud?
Yeah.
I don't know that I can pronounce that last name correctly. I may butcher it. But
we've been doing that all day long here with
Dolores. Dolores Roethler Farm Trust.
Right. Roethler is spelled Roethler, correct?
Yes.
So this is a county assessor map that appears to depict an owner of Dolores Roethler Farm Trust, correct?
Yes.
Appears to be on a 40-acre parcel located directly north of where DePayma's parcel was, correct?
Yes.
Okay. Move to enter DePayma exhibit 3, hearing exhibit 3.
Are there objections?
No objection.
The board will admit DePayma hearing exhibit 3.
I'd like to now go to DePayma hearing exhibit 4. Okay, I'm going to represent to you. Is there a marking of this thing? Tech on the upper left? It doesn't appear to be a marking. Mr. Chair, that this exhibit is not marked. I may have submitted an exhibit that was not marked. DePayma hearing exhibit 4. I'm asking the chair for some guidance on how to handle this.
appears that it's not labeled, so unless there's objection, we'll get to that in just a moment. We'll have you refile it labeled as the payment hearing exhibit 4. Just want to make sure we weren't going to be out of sequence. But are you moving to admit it?
Well, before we do that, I want to make sure that Summit sees that marked exhibit before I file it, and with their stipulated consent, we'll do that. My promise to the board is when I have the ability to do that, I will do that.
Okay. Is there objection?
Candidly, Your Honor, I don't know because I don't know what it is yet.
Okay.
Let's lay some foundation, maybe?
Perfect. Appreciate it.
All right. Well, this document, which is before you, Mr. Rorie, I'm going to have the tech, I'm going to suggest to you it appears to be an easement agreement, and I'm going to have the tech go ahead and page through this slowly so that the witness can look at it. Let's go to page 2. Let's now go to page 3. And page 4. Let's get to the bottom of that page. Now page 5. And page 6. Okay, now let's go to page 7. This appears to be, Mr. Rorie, on page 7, a signature page. Would you confirm that for the record?
Looks like a signature page, yes.
Looks like a signature page of a person under the title Dolores Rothler Farm Trust, correct?
That looks like the grantor, yes.
Let's go down further to page 8. Now, another signature page of another, perhaps, trustee. Is that correct?
Looks like that's the case.
So the Rothler Trust have apparently 2 trustees, it appears, correct?
It's the way it looks to me.
Okay. Let's go to the next page. Here's an exhibit A. That's page, I think, 9. Okay. Let's go to the next page. That's page 10. And now page 11. Okay. Okay. Now let's go back to the top on page 1. So, on the top of page 1 of this document, which appears to have some recording information in the top right, you would agree that appears to be a county recorder's doing, correct?
Yes.
So, as you had a chance to scan this document, and without commenting on the specific language, I know you're not a speed reader, Mr. Rorie, can you confirm that this looks like an easement agreement of your company?
Yes.
It was an easement agreement prepared by your company, wasn't it?
It looks like one of our easement agreements.
And in fact, it looks like an easement agreement that was secured by the Dolores Rothler Farm Trust, correct?
Secured by them?
Oh, excuse me, given, thank you, given by them to Summit.
Yes.
And then Summit thereafter took this easement that they signed, granted to Summit, and filed it of record on, what's the date that it was filed, Mr. Rorie?
May 25th of last year.
May 25th of 2022. So there it is. Mr. Chair, I'm going to ask for this exhibit to be entered once it is marked as DePayment Hearing Exhibit 4.
Are there objections?
I guess I have a question. Mr. Murray, this easement agreement, which will be marked Exhibit 4, is not for the parcel directly north of the DePayment parcel?
That is correct. I'm going to concede that point and actually acknowledge that point and stipulate to that point.
No objection. Okay. Seeing no objection, the board will admit as to payment hearing Exhibit 4.
So now where we have to go Tech is with the Exhibit H filed on September 7, 2022 concerning DePayma. Okay, so on the screen there is September 7, 2022. We have what appears to be an Exhibit H filed on that date, correct?
Yes.
And it does appear to concern DePayma LLC, correct?
Yes.
DePayma being a parcel in Kasuth County, parcel number IAKO 102.0097.000, correct?
I have to see those numbers you just listed, but I'll take your word for it.
Okay. Page 5, please. Oh, I overshot. Page 4. Okay. Now, I'm going to suggest to you that on page 4 of this Exhibit H, there appears to be a survey proposing a route on this parcel owner. Does this appear to be a route that has been prepared at the direction of Summit?
Looks that way.
And of course, it would have been a route prepared at the direction of Summit. I just lost it. This is an straight east-west route, correct?
Looks that way, yes.
And this straight east-west route appears to be very close to the north boundary of this parcel, correct?
Yes.
And so, if you can, by recollection, not by visualization, but recollection, remember that the route, or rather the parcel to the north of this parcel is owned by the Dolores Rothler Farm Trust. Would you understand what I'm saying?
I'd have to see something else to confirm that.
Okay. Well,
this isn't going to show me anything about the northern tract, and I don't want to misspeak. I'd have to see who owns what's to the north. And again, KMZ would be very helpful for me here. So I'm not looking at one while talking about another.
I'm sure you'll get a chance to answer with respect to your KMZ. My client's going to testify that the Dolores Rothler Farm Trust owns that parcel to the north, okay?
Okay.
All right. So, Mr. Rorie, has Summit explored the possibility that this pipeline can be at least moved upon the parcel to the north?
I don't know.
Certainly, with DePayma being an unwilling landowner, you could have minimized the impact on the DePayma property by simply moving the route a little bit to the north, couldn't you have?
Well, that word simply is your word, not mine. I don't know that I fully understand your question, but minimize the impact on a property by getting off of it. Obviously, that would minimize the impact on a property if you weren't on it. But simply is a bit of a key word there.
Let's take that one down off the screen, Tech. Let's go back to Crot. And I want to talk about the filing on September 12, 2022, Exhibit H, page 5. Yeah, there you are. Page, well, no, right there. Let's just stay right there. This one here on the screen appears to be the Exhibit H filed on July 14, 2023. Do you see that there?
I don't see the date. Yep, that looks right.
So you would concede this is what we'll call the current route on the property, correct?
That's fair.
This is part of the route that your COO, Mr. Powell, had said there's only one route. This is part of that one route, correct?
This is the route we're seeking.
And then if the tech can now put on the screen page 5, which was filed by Summit on September 12, 2022. This is the boundary route, okay? You see that there?
Yes.
Would you not concede that this boundary route, as I've labeled it, was and continues to be a possible alternate route?
See it as a very unlikely route, but suppose anything's possible given the recent ability of both parties to find a way to reach an agreement. But again, to answer your question, you conveniently mentioned the entry into the property, but you didn't mention the exit. And so that property to the north has reached an agreement with us to enter their property differently. So it falls back into your term of what's simple and what isn't. But as far as considering a route, I think that proves that we considered this route a while ago. And there were factors that I believe we both understand would have caused that to be unworkable, period. So now what this is asking us to do is to go back to the neighbor to the north, impact them differently, change our tune with them in order to accommodate what was not going to be a workable route, given all of the parameters of the discussion, which I think it's best we not disclose those. But that route right there is not workable given the parameters of the agreement. And now we're in a situation where we're going to be impacting somebody to the north if we agree to this. So we've invited parties that aren't talking to me right now about this, and to my knowledge, you don't represent them. So you mentioned earlier that, at least in Friday, there's 892 parcels yet to be signed. Do you remember that testimony? I do.
Of those 892 parcels yet to be signed, how many have had multiple Exhibit H surveys prepared?
I don't know. I didn't prepare them, so I really couldn't answer that. I couldn't even guess.
How many Exhibit H surveys have, how many of those holdout parcels have multiple Exhibit H surveys filed with the Iowa Utilities Board?
Same answer. I have no idea, except for, again, I don't refer to them as holdout parcels, but I don't know. I don't know the frequency of that.
So then Summit cannot identify the total number of possible alternate routes. You don't even know how many of those parcels have even been surveyed multiply.
Well, you're misrepresenting what I'm saying, Mr. Murray. I'm not saying Summit can't identify that. I'm telling you I can't. I don't issue the Exhibit H's. I don't draw them. I don't keep a tally of route requests. I can tell you they're frequent across a 2,000-mile project. So I don't agree with your statement that Summit can't produce that. And I suppose if they had to, they could. But I can't. I don't draw the Exhibit H's, and I don't track the reroute requests.
Mr. Chair, I've only got one more line of questions, and I suspect it'll last about 5 or 10 minutes. May I proceed? I think I will wrap it up here.
Yep, of course.
Thank you. I'm going to have the chair or the tech publish the payment hearing Exhibit 2. Okay, we're back to this county assessor map for DePayma, hearing Exhibit 2. It's on the screen here, okay?
Okay.
So, I want to actually get some terminology clarified here, okay? And this is not the right exhibit to do it in, but I'm just going to suggest to you that with respect to the Exhibit H filing, what I see are phrases that have these terms in it. Permanent easement is one of them. Do you recollect the use of the reference permanent easement?
Yes.
And can we agree that the permanent easement is this usually 50-foot wide area that is more specifically described on the Exhibit H, correct?
That's right.
Thank you. And with respect to the temporary construction easement, that is another area that's specifically described by meets and bounds, just like the permanent easement, correct?
Sounds right.
Thank you. We can go back to an Exhibit H, but I also recollect seeing a term entitled property with initial caps P for property.
Okay.
And I see that term as referencing the overall parcel that the owner totally owns that's affected by this action. Would that be a fair thing to say, or should we put it up on the screen?
I have to look at one, but I think there's a parent parcel description there, and then a meets and bounds of the easements, but I have to look at it.
All right, let's go there. I think we've got one up. Lyon County, April 18, 2023. No, is it April? Yeah. April 18, 2023, concerning Crot's parcel. Let's go up to page 1. All right, let's go down a little bit. All right, there you are on the bottom of page 1. It's entitled Property Legal Description. The following property may be referred to as the, quote, property, end quote. Do you see that?
Yes.
All right, good. Now let's go to the next page. All right, and on the top of the page, it does appear to give a legal description of that parcel, correct?
Yes.
All right. Now, unfortunately, our tech chair couldn't read our mind and went to Crot instead of to Pema, but we'll just go ahead and use this as an example. This is an example of how we define a property, correct?
It's a parent parcel.
Parent.
What we refer to it.
The parent
We
parcel.
refer to it as.
All right. Parent parcel is what you Summit define as, quote, property.
Yes.
All right, good. Now, you would agree with me that the property, being the parent property, has greater area than the permanent easement, correct?
Yes.
And it has greater area than the permanent easement and the temporary construction easement, correct?
Yes.
So if I were to refer to the remainder of that property as the remainder of the property, you would know what I'm talking about.
I would.
Very good. I'm going to suggest to you that DePema's Exhibit H has a similar characterization. It's just a different legal description, okay?
It's your suggestion.
We're not going to go there. We're just going to go back to that map we had up, which is Hearing Exhibit 2. Okay, so here we are. Now, tech expert, please go back to the last one. I'm sorry. I'm very sorry. Now let's go down. And in page 3, under easement rights, okay, let's go down to little number 4 and blow that up. Okay, you see where it says the right of unimpeded ingress and egress into, through, on, over, under, and across the easement areas, left parent, and in the event of an emergency over such other portions of the property as may be reasonably necessary, right parent, comma, and then it goes on. Do you see that?
I do.
Would you agree with me that as it relates to the remainder of the property, not the property, but the remainder of the property, would you concede with me that the remainder of the property is affected only in the event of an emergency?
Unless there was an access easement area defined and depicted, that would be the exception to, I believe, what you're pointing at. Does that work?
I just want to make sure that with respect to the remainder of the property, being that property that's not the permanent easement, not the temporary construction easement, with respect to the remainder of the property, the only use you're getting here is an ingress-egress for emergent conditions. Correct?
Emergency conditions.
Emergency.
Unless there's an access easement further defined in there, that would be the only exception, I believe, to what you're asking.
And the access easement that you're referring that could possibly be defined in there, that would be those access easements that are described by meets and bounds, correct?
Yeah, typically they're a road.
Right. And from purposes of my question, I'm not referring to those specifically worded access easements. I'm talking about this one that's on the screen.
I understand, but you're talking about the remainder of the property, and that's an exception to your question. So, that if there were no access easement on this property, shown on the Exhibit H, if your question is, would we need reasonable access in the event of an emergency to get access to our pipeline on the remainder of the property?
No, my question is simply this. The only right you're seeking here to affect the remainder of the property is this unimpeded ingress-egress in emergency conditions. Correct?
That seems right. I just have to look at the route and see if there's an access easement. I feel like that's maybe the third or fourth time I've said it. If there's an access easement, if it's in play, I don't know. I'm not looking at it. If an access easement was in play, that would be in addition to the remainder of the property. If there isn't one, then we're talking about emergency access only, yes.
And if we were now, tech person, to go back to DePayment Hearing Exhibit 2, as it looks here on DePayment Hearing Exhibit 2, we have a parcel that I'm going to suggest to you is the parcel that's described in your Exhibit H, a 40-acre parcel. It has no roads connected to it. Would you see that?
I'm not zoomed in enough to see if there are no access roads connected to it. You're talking about public roads?
Public roads. There's no public roads that get connected to this parcel, correct?
I don't see any in this map. Doesn't look like it to me.
So, if your COO had mentioned, I asked him about what is constituting an emergency, and of course he was very fair about it. He said, well, if we have things that affect the integrity of the pipeline, we got to get out there. An emergency, do you think that anybody's going to look at a plat map or legal documents to go out and address an issue? Do you really think that's going to happen?
I don't understand your question. Well, in an emergency, are they going to look at a plat map?
Well, my question is this. Let's say you have a leak on the north side of this parcel. Do you actually think the emergency response team is going to come in the south road and not do anything, not go across that parcel to the south to get to the north? Do you actually think that's the case?
I don't know what they would do. I think they would get to it as fast as they could where they legally could access it.
Well, does Summit know what they would do?
That's a broad question. What they would do with what?
With an emergency.
It's even broader. I don't know how to answer your question. I know that I'm trying my best.
Yeah.
And you're sort of hammering the same broad global words that I couldn't possibly describe that accurately for you. So if there's an emergency on this property, they're going to try to get to that pipeline as fast as they can. Do they have an idea well ahead of time where there's legal access? Our ops group certainly would. Okay. So it's the best I can do to answer your question. I don't fully understand how to answer a question much broader than what I just described. I do my best, but I don't know how to get better than that.
Mr. Rorie, I appreciate the time with you today to discuss these issues. I have no further questions.
Thank you.
Okay, thank you, Mr. Murray. Mr. Meyer, you're up next. However, we're going to take a very brief 15-minute break.